I'm just going to, before we start, I am going to um, give some information about the anti-casualisation committee. We have been around for a decade and a bit, I think 2 decades, a decade, I can't remember. But we are here, of course, to keep reminding our whole union that casualisation should be stamped out. Um, I want to mention that we are a committee that meets a few times a year, shaping the union's work on casualisation, leading campaigns, and so on. This webinar series has come about because of hard work from members on the committee. We do some work with the Equality Committee as well. We know that casualisation and equality are very much tied together. With, of course, women, people of color, disabled people more likely to be in casualized situations. So we have the committee. There are still some seats open on the committee. So if you are interested, and I can mention this again at the end, because hopefully after this hour you'll be even more interested and engaged and wanting to become more involved. If you are interested in joining the anti-casualization committee, please do so. We have some seats open, and so we can co-opt new members. And I think Mary Meekings will be sharing a link, or you can just look us up on the internet and find the link to nominate yourself. Nominations close 3rd of June. First of all, we are recording. Quite a few people wanted to be here, but they couldn't, so we're recording this session for everyone who wants to join in and look and rewatch later on. So please be aware of that. In terms of what the format of the session will be, is that Ian Higham will give us a talk on the issue of these fake open-ended contracts with review dates and all their names. So Ian will be talking for about 30 minutes, and then we can have some questions for Ian from all of you. And then hopefully we'll get some more discussion going and input from everyone here to see how you are dealing with these kind of contracts in your own institutions and wherever you find them. I think that's about it. Ian, I'm very happy to hand over to Ian. Ian is the branch chair at London School of Economics and also a member of the Anti-Casualisation Committee.
Thank you so much, Lena. I hope everyone can hear me and see the slides. Please let us know if you can't. So yes, I'm going to be presenting on open-ended contracts that have an end date or maybe just aren't open-ended, and sort of talking about lessons from the London School of Economics branch, how we've gone about learning about these instruments and at least starting to challenge them or to kind of pick them apart, if not to completely successfully challenge them so far. So just a quick overview of kind of the key arguments that I'll make or the key points that I'll highlight roughly in the order that I'll do so. The terminology for these contracts varies a lot across the sector, and that could affect whether these really are permanent or fixed term or where in between. There's maybe not a spectrum, but if there is. And I'm also going to try to argue that this is a really important issue. It's something we do need to tackle, but at the same time, the type of contract that you're on only offers a certain amount of employment protection, and there need to be other things that also need to be happening in this space. And I'll talk about what is distinct about these contracts that makes them both better and worse, maybe than certain fixed-term contracts or permanent contracts. And I will also talk about how employers obfuscate the reality of casualization using statistics on these contracts, including their sort of creeping use for different staff groups. And I'll try to highlight some actions and strategies that I think we can take forward, both at branch level and nationally. So just to be clear, it's a bit confusing as to what we're talking about. And I'm going to focus on contracts for those of you, I think most of you will know or have an idea of what it is we're talking about, but I'm going to try to be broad. We're basically talking about contracts that are not fixed term or temporary in name. So they don't say fixed term on the tin most of the time, at least. They might have that kind of in the title. But they're not permanent either, or they might be called permanent or open-ended, but they're treated very differently, perhaps even exactly the same in some cases as fixed-term contracts. I'll probably say open-ended subject to funding the most often because that's the term used at LSE. So it is sort of this simplest shorthand for me. It's familiar. But unless I'm specifically talking about one of these titles of these contracts, I do mean kind of the broader family of them. So, just quickly, I hope most of you will know this, particularly maybe if you've been involved in casework or certain negotiations. But the Fixed Term Employees Prevention of Less Favorable Treatment Regulations 2002, not the easiest title, defines what a fixed term contract is. And it does so in a way that establishes quite a binary with a permanent contract, where a permanent employee is just anybody not on a fixed term contract. But there are three ways that a contract can be determined to be fixed term, and that is whether it expires at a specific term on the completion of a particular task, or, and I think this is crucial, probably the most crucial for what we're talking about today, on the occurrence or non-occurrence of a specific event other than retirement. However, there is, as far as we've been advised, I should say, I don't know if I said this in the first slide, I'm not here to give legal advice. I'm not a legal expert, but we have taken legal advice at branch level and kind of tried to reason about the law. We're not aware of any appellate case law on these contracts that would establish sort of exactly where they fall against these criteria. And I just want to give you some examples of how these contracts differ across the sector, in name at least, and I think that could affect possibly their legal status in certain cases. So at LSE, like I said, they're open-ended subject to funding. At Manchester, they're finite funded but permanent. At UCL, they're open-ended with an end date. I should say these are at least on the website. You may know that they're different. Oxford Brookes, permanent subject to the continued availability of funds and ongoing work. Nice, concise title there. It's really difficult to search for these terms and to do any kind of comparative research. Not that I did this in such a systematic way, but because not every university publishes this information at all, particularly not the post-92s, but also because they use such different terms that it can be difficult to even conduct this kind of search. I should also say that I'm at least personally aware that these are used outside of the higher education sector. I had a colleague, for example, who went to work at an NGO where this was being used, and actually that NGO phased out the use of them because they felt that this was illegal nonsense, essentially. And I wonder why, or I'm posing the question to all of you, why these different terms are used. And I think it might suggest that employers are not super confident in their own legal position. It's not as though they are taking one piece of advice and implementing it in exactly the same way. And I can say from the LSE experience, they're very concerned that their particular wording matters. And you would think that if they were super confident in that, then other branches might be seeing the exact same wording, and they're not. So I think we should be asking why these differences are there and what they mean. But in all cases, as we've been advised at our branch, and as I think should be obvious, what really matters is whether the contract does or does not satisfy that definition in the 2002 regulations. I think that's more important than what's on the tin. If it says permanent, but it has an end date, it's really hard to justify that it's permanent. And where it specifically mentions the end of a project or the end of a piece of funding, particularly giving a date, that would probably be a specific enough event to qualify the contract as fixed term. It doesn't have to give an exact date, although in our sector you would normally expect to see that. So, for example, fruit pickers would normally have a fixed term contract that does have it end at a specific event, but maybe not a specific date, like when the harvest ends. I I think for the most part you won't find that in the higher education sector, but it could be happening in certain contexts. But we are basically advised at our branch using, only the specific wording, at least that LSE is using, that if a contract is subject to funding and it's specifying the expected end date of the funding, and especially if it's saying the project and the source of the funding, it should more or less be understood as a fixed term contract. It probably does meet that legal definition, although there is some scope for ambiguity, for example, in how the contract gets extended and when it is or isn't permanent. So why do these matter? Or I guess I should say, does this matter? Trigger warning for the photo of Margaret Thatcher. My colleague won't let me use my Thatcher the 10-year snatcher slides, so I stopped doing that. But a permanent contract, as I said, is a binary, right? It's just it either is or isn't permanent. It either is or isn't fixed term. But even when you have a permanent contract, it's really, really important. And I don't want to downplay the the issue that I'm here to present about. But we need to remember that a contract is never going to protect you from redundancy, no matter what it says. Tenure does not exist in this country anymore for anybody. You might hear, particularly at my institution, you will hear people using that word, but it has not existed for anybody who's hired or promoted since November 1987, which I think is basically everybody on this call. Um, Redundancies across the sector also show us just how important funding can be to keeping you permanent, keeping you employed, regardless of the type of contract that you're on. So it is really important that we solve this issue. And I think that we just need to bear in mind that getting people onto permanent contracts is about, I do not want to say changing hearts and minds, but it's about partially changing the perception that people have of these things. Um, it's a means, not just the end goal in and of itself. Um, so just because the question of redundancy then comes up a lot, it is illegal to treat a fixed term contract less favorably, but employers often try to find loopholes like they're discriminating within the category of permanent or within the category of fixed term contracts. And so they think that maybe they can treat these a little bit differently. Regardless of the type of contract, whether it's fixed term or subject to funding, the end of that contract is a dismissal. And after 2 years, and soon to be after 6 months, the dismissal must be fair. And there are only 5 reasons for that. So sometimes, they're usually not related to research funding, when a fixed term contract comes to an end, there's some other substantial reason, justification for that ending, and there's no redundancy process. But for the most part, where research funding is involved, that could mean that the employer needs less work of a particular kind, and they often treat it as if it automatically means that. So you could be selected for redundancy. Uh, these open-ended subject to funding contracts seem to at least trigger a more effort by employers to pretend that they're doing some kind of redundancy process, but there's often still just a selection pool of the one individual without any real process being followed. And at my institution and many others, some of the more robust redundancy policies that are meant to apply, for example, from their statutes, are just not applied. So what would be the benefits of this? Is there any reason you'd want to be on an open-ended subject to funding contract? Possibly. We're aware that, for example, the UKRI treats these as permanent, where that's a requirement to apply for a grant, which they wouldn't do for a fixed term contract. Some colleagues have had an easier time securing loans and mortgages. Probably most of them have had a relatively easy time. But at my institution, at least, that's because banks have been willing to write letters verifying these contracts as permanent. But it's still really difficult, especially where the end date is quite imminent. And then different branches have negotiated different benefits that may apply only to these subject to funding contracts. For example, an automatic bridging period at Manchester. But of course, they also have drawbacks that are sometimes the same as and sometimes different from fixed term contracts. For example, this would be, of course, the same with the fixed term contract. But if you wanted to buy unemployment insurance, benefits are not that high in this country compared to elsewhere, despite the political discourse around them. And if it's showing that you have a known risk of redundancy, you will almost certainly not be able to purchase unemployment insurance. These contracts also create an ambiguity. So, you can't just leave at the end of it. You're not just going to be dismissed at the end of it. So there's a stringing along. And, we've done a survey at our branch and people say they feel like they're constantly under performance management. Like maybe you get to stay if we find some funding. And at the same time, you can't just walk away, which can make people stressed about things like, well, my contract says if I leave early, I have to give so much notice, or I have to pay back my visa reimbursement or something. And so what do I do if some permanent opportunity comes along and I feel that I can't leave, whereas I could just not renew my fixed term contract? So that's a point that comes up sometimes. And a lot of branches, at least my own, and I've heard many others, do not render these contracts permanent after 4 years the way that they might with a fixed term contract. They say it's already permanent. And of course, and we'll talk about this more, the public reporting aspect. But I think the biggest issue is one of treatment and perception. There's a tendency to see these as fixed term, no matter what it says. It reinforces the idea that an individual job or individual employment is linked to a specific piece of funding. Staff, including often our members, because they're just not informed, might just think this doesn't really count as a redundancy when it ends. They don't really understand that maybe this should be a permanent contract, or they just don't know what it is because the idea of a permanent contract that ends doesn't make any sense to them. And of course, this can give employers this kind of sense of legitimacy that probably should not be there when they select solely on the basis of your funding ending. They feel that that gives them an out where they don't need to do pooling. And I'll just say briefly on this, the public reporting aspect, because I think it is really important. So a lot of employers, and we'll get to mine in a second, um, used to report these contracts mostly as being precarious, as being fixed term. HESA, the Higher Education Statistics Agency, no longer requires that. In fact, they advised, at least they say that they look at the specifics of each individual case. But at LSE, they say the circumstances justify calling these permanent contracts. And they say that this has been confirmed with the Office for Students, the regulator, although I note it's not a labor regulator, so that was a strange place to get that confirmation, one could argue. Um, and that data feeds into public perceptions about casualization. It gives universities reputational enhancement, and it might be used in the REF 2029. I don't think that's sure yet, but indicators on fixed term contracts will be used, and they're very likely to end up being drawn from the HESA data. So this is a big issue that employers are kind of getting around having real transparency on this point. So let's look into LSE a bit closer. Um, so we have these contracts called open-ended subject to funding, and LSE insists that they're permanent, although then on their webpage they call them fixed term. Locally, they're always referred to as fixed term, basically by your line manager, the head of your department or center. Um, but they are called permanent when you ask HR most of the time. They're advertised. Usually, the jobs that lead to these contracts are advertised as fixed term. My own was. Sometimes not, but for the most part, they're advertised as fixed term, and then the contract is subject to funding. When we ask about this, the employer says it's because they would have to do an international search if it were properly advertised. I don't know what that means. But many staff, I will just say, don't know what type of contract they're on. They ask us. I think we've done a great job of raising awareness of this, but it took a while, and still people don't always understand. Um, so this does affect primarily research staff, which I think most of you will know. And at LSE, that includes what we call policy staff who are doing more applied research. Although we think they're more likely to be on fixed term contracts, and we don't totally know why. We've not gotten clear answers. But we are seeing limited but definite usage for teaching staff. I'll give you our statistics on that. But when we did a survey, we had 4 out of 115 respondents. So we think it's low, and we cannot see any kind of pattern yet, but we think it's there. But we're also seeing them increasingly for professional services staff. So that might, I mean, I don't want to say make sense, but it might be logically consistent that we find that where a project manager was budgeted for in a specific grant. But we also see it in central administrative units where there's no obvious link to external funding. Sometimes there could be, for example, a curator, an archivist, or something. But for the most part, we are seeing it just randomly, and we don't really understand why. Um, these contracts, kind of the individual becomes treated as responsible for funding. You can see why that's a problem, especially for professional services staff. They don't always align with the actual funding available. So there'll be a large philanthropic grant, and you get an allocation from that core grant, even though the core grant goes on longer. And that's where this idea that I'm being subjected to performance management can come in. But also, just sometimes someone has 2 grants, and the contract will end at the earliest date that one of those ends. So we don't get new contracts most of the time. We get these sort of funding extension letters that are a bit ambiguous, and that does obfuscate a little bit whether are they permanent or they fixed term. But as I think is happening across the sector, the redundancy is still sort of treated as the foregone conclusion. So I just want to note really quickly, 2023 was the year where LSE stopped reporting these as fixed term and started reporting them as permanent. If you see that the pink line is fixed term, I think the trend is just really obvious. We've been meeting with other branches, and someone from Oxford said to me, "What did you do? How did you make this happen?" And I said, "You need to look into this data. These are just these open-ended subject to funding contracts." And so this is, I think, exposes the real problem with this reporting. Also, this line, just to note, shows what a problem we have with the lack of permanent jobs that 10 years ago exceeded the number of fixed term, even counting these contracts. I won't go through this in detail, but just to show these are the numbers of staff that we have. So you can see, well, they divide the hourly paid research staff and the salaried ones, but it's relatively small numbers of groups that are most likely to be affected. But it's actually not entirely small school-wide. It's fluctuated over the years, but hovering around 10%, currently at 8%, that are on these types of contracts. And you can see our casualization situation is not great overall. This is all staff of all categories. For research staff, we can see the usage is high, but the usage of fixed-term contracts remains higher. And we do not know why we've suddenly got 5% permanent research staff. For teaching staff, you can see it's consistently been 4% on these contract types. Again, we don't know why. This is a variety of different positions of sort of traditionally fixed term teaching staff, but it also includes education career track staff, which are permanent. For the traditional kind of faculty, nobody's on these contract types. For professional services staff, it's broadly increasing as a trend. And we don't, as I said, we don't really understand why. And that is happening even in central administrative units, although it's been consistent in those units. So this is where grant funding is not relevant. Um, and in research institutes where we also have professional services staff working, there is somewhat of an upward trend, although it's suddenly declined quite sharply in the past year. But it remains probably the most, or it is the most predominant form of employment, these contracts. So LSE likes to have it both ways. They treat it as if these contracts are permanent and not permanent, depending on what's convenient for them, at least in my view. And as I said above, the 4-year rule does not always help. This idea that you become permanent after 4 years of renewed fixed term contracts. So in 2024, the school told us that they would honor that, and after 4 years, these are made permanent, although they've been using them for decades and not doing that. They walked that back in 2025 and said, well, they're already permanent. But they said they would convert fixed term contracts, except they just convert them into open-ended subject to funding contracts. As I said, we have had an uptick in permanent research staff, and we don't really understand why. The school has not answered that yet. But I don't think it's that there's some sort of systematic process of converting these to permanent. So I won't go through all of these, but it's important to think through the consequences of this, also because it has helped us strategically to kind of win some gains from the school. So we have internal funding schemes, these smaller pots of money that you can apply for conferences or whatever. And they always say that your contract needs to extend beyond the end of your proposed project, but they treat your contract as if it ends when the funding ends. And we've tried to say, well, if it's open-ended, then that can't be the case. It can't be permanent, but not extend beyond that. Yet for things like if you want to apply for a career development coaching program, that does not apply. So currently, we have a Section 188, a collective redundancy consultation, where they only need to count permanent contracts, and they are, in fact, treating these as permanent, which is a bit of a surprise. Or at least we think. We don't have all the data to confirm that. But so it's very inconsistent. So that said, we've recently made some gains at branch level, and not strictly about these contract types. But I think it's important just to note, because it's come up a lot in that context. So we've negotiated terms of reference that need to be formalized and approved, but they will involve negotiating basically a way to have pooled funding, at least within research centers, if not across the whole school. A commitment to minimize fixed term contracts and increase permanent contracts, which, as we noted, was really agreed at national level in 2002, but better than not having it there, I suppose. They would not commit to calling these fixed term contracts, but they acknowledged that they may need to be treated that way. They not only reforming bridge funding to make it more accessible. So in the past year, we had nobody get it because of the rules. It just makes it impossible. But also to reform these other internal funding schemes to consider these contracts a bit more permanent for those purposes. And we're also, we have a commitment to negotiate ways to reduce barriers to promotion that arise from funding. So, you're not allowed to budget for your promotion, and yet you're not allowed to be promoted if there's no money there for you. And then we've also got a commitment to negotiate better workforce planning and improved redundancy opportunities. So I think I put this here partially because I think it's important that we've tried to remain conscious that no matter what type of contract somebody's on, we have to be building the infrastructure that facilitates meaningful job security. So what can we all do? Just kind of, basically distilling tips for branches from what we've done and what I think could work. Start identifying those inconsistencies and logical fallacies. So start looking at things like internal grants and training opportunities and saying, well, look, if the contract has to extend beyond this and you won't count that funding date as, you count that funding date as if it's a foregone redundancy, then it's not an open-ended contract. Try to have it both ways. Say, well, if these are permanent, then you need to be consulting us collectively on the redundancies. And if they're not permanent, say, well, then after 4 years, they have to become permanent. This has really gotten our employer to start thinking about what they're saying and why. I think it's important to seek legal advice where relevant. Having that advice has really given us a clearer view on what we're doing, and I think we sound more credible. At the same time, I don't think litigation is going to be a panacea here. I think there are serious limitations on what precedent will do and whether it's worth pursuing that way. I think it's important to disseminate knowledge within and across branches. So we've done some Know Your Rights trainings about this issue that have been really good. We've gotten a lot of recruitment out of that. Also, we have a national working group on pooled funding, which is not exactly about these contracts, but very much relates. So please get in touch with me or I'm not sure who actually, but with me, I can connect you if you'd like to join that and chat with us. It's very informal. Join or share information with the ACC. Lena talked about that, and we'll do so again. And try to, as you learn about these contracts, incorporate that in your trainings for your caseworkers and your committee members. And then I've just laid out some ideas, and I will wrap up here. I hope I'm not too overtime. About ideas for what we can do nationally. I think we need a coherent position on what we think about these contracts, but also we need to have space for these local variations. I don't think it's obvious that they are all the same. You know, a review date probably is less conditional than a subject to funding clause. And one could argue that maybe one is more permanent and one is more fixed term. I don't think we know that yet. So we need to kind of have a coherent national view and work together against this while also recognizing that the legal interpretation may differ. I think doing that, it could be useful to build a library of contract templates from across the sector. I'm not sure about the administrative and bureaucratic capacity to do that, but I think it could be a useful exercise. I definitely think we need to be considering possible legal strategies, but also being aware of what that would cost and how much value it would bring. Um, I think just getting a better understanding in general about these things and sharing that information is really important. Also, and I didn't spell it out here, but thinking about how it intersects with other things. For example, equalities. You know, do we know, do we have the data? We are getting the data on how this intersects with different, you know, are fixed term contracts more used for certain groups than for others with the open-ended subject to funding? And also, how does one create more or less mental health struggle with casualization? And I think that involves also mapping out the usage of these contracts for staff other than research staff, such as professional services. And then a big one for me would be, I guess I tie the lobbying the government together with challenging HISA and the Office for Students on these classifications, because I think it would be a real shame if employers benefit reputationally from this, and if that informs their ranking in the ref, that it makes it look like they've got all these permanent contracts when they don't. But I will just reiterate that I really do think we have to ground these actions in a strategy that challenges all forms of insecure employment and builds an infrastructure that can actually sustain permanent employment, because just having that on the tin of your contract is not going to be enough. It's not going to protect you from redundancy if the employer is not actually putting the money behind your position. So I'm happy to take questions and would encourage you all to share insights. And I hope I've done okay on time, and thank you.
Thank you so much, Ian. That was fantastic. Um, and yeah, applause from me, and kind of still catching up with all the thoughts. You already, while you've spoken, you've already had several comments and questions come in. And I want to mention that there is a motion at UCU UK Congress later on this month on these kind of open-ended with review date, fixed term permanent, subject to funding. So hopefully that will be something UCU will also be centrally working on more. So we have a few questions and people thanking you as well. If anyone wants to speak, feel free to raise your hand and we can hear you. But we've heard from Ellen that another term is permanent with fixed funding end date at Birmingham. And Vashti is asking, she's been told that their contract open-ended with review date does not qualify to apply for UKRI funding. Do you have a link to the contrary?
Not ready to share, but the quote that I had on the slide, I did take from their website. So, well, I can say that I've applied for these grants before and it's been accepted, but no, I don't have a link ready. If you want to email me, I'm easy to Google and I can try to help you out. Also, you should talk to your research division at your university. Like, they should know about this. I mean, they're the ones who invented these contracts partially for that reason. So,
And then another question from Ellen is the legal advice you have obtained from UCU?
I'm not sure what we mean by from UCU. It's from a barrister, but it was UCU enabled us to get that advice. But it was in the context of negotiations. It wasn't like we just randomly were supplied.
And You have another question. There are several LSE staff members at the International Growth Center on open-ended subject to funding contracts who are at risk of redundancy. There hasn't been transparency what this will look like, especially since several are on visas. Who can they contact to work with UCU on this?
Um, so this is a very branch specific issue. The International Growth Center redundancies were included in a recent Section 188 letter sent to the unions, plural. Um, we were only told that funding is being reduced and that there are 20 posts at risk. That's all the letter says. It says nothing about contract type, which fixed term would not be included normally, or wouldn't have to be, but we don't know. And it says nothing about the type of staff affected. And because that center uses a lot of contractors in other countries, it's very difficult to really ascertain like who would be affected. We were subsequently told orally that it's likely to be only professional services staff. My intention is to organize a meeting with the other unions and with the affected staff, but I think we need a bit more information. We don't even know when the school will consider that consultation to actually begin because we don't legally have enough information for it to have begun. So I don't think the contract type will be that relevant in terms of the redundancy consultation because they are, I mean, I'm not defending my employer, but they are committed to having that conversation. But this is very niche for everybody else. So please write to ucu.secretary@lse.ac.uk and we'll get back to you as soon as we can.
And you have even more specific questions that I'll continue to read them out. My favorite question so far is realistically, what is the situation of someone who has one of these contracts? And I think kind of together with that is, can you explain what the difference is between fixed term contracts and open-ended fixed term contracts with respect to redundancy?
So what is the situation? I mean, like I said, I think it will always depend a little bit on your exact contract and your exact employer. I don't know, and we won't know until we get more information sharing and more legal advice. You know, if Edinburgh is, I know I think there they say with a review date. Um, Reviewing your contract is different from ending it. So, and it's not a condition per se, it's just a review. So I don't know if they say, but you'll be made redundant if there's no funding at the review, then I think it would be pretty clearly a fixed term contract. Whereas if it's already expressly like open-ended with an end date, it's pretty hard to say that's not a fixed term contract. Like there's an end date. So that situation might differ a bit. I think in reality, it's pretty much across the sector the same phenomenon of being on a perpetual fixed term contract in practice. And like I said, it can feel, particularly where you're in a center that, or a research center or a department that has large philanthropic funding or big grants controlled by powerful PIs, where they might say, well, we might be able to extend your contract, but we won't. It can feel, I think, even more than a fixed term contract, like you're being strung along, constantly performance managed. So at LSE, in my experience with casework, at least, we see fixed term contracts are relatively, it's kind of either 1 year, 2 years, or not. Whereas these contracts are like 3 month extensions, 2 month extensions, 2 week extensions. And that can just, it's chaotic administratively and certainly, for mental health. So the situation, well, it's just constant precarity. It is probably the same as that for a fixed term contract. I think in terms of redundancy, there's not much of a difference in practice. So I can tell you at LSE, a fixed term contract says um, that there will be no notice period, that it will just end on the expiration date that it ends. However, if in law it amounts to what would need to be a redundancy to be fair, they will go through the motions of some kind of redundancy process, not the one that applies contractually, which is the model statute procedure that we still have, but they will go through some kind of redundancy process. Where it's open-ended subject to funding, there's a proper notice period, where there's supposed to be, and they acknowledge that, and well, let's say mostly adhere to it. But effectively, there's always a pool of one, and they treat it as though that clause about being subject to funding doesn't require them to look across the university and pull the funding, and that they don't really need to look for other funding. So I think that's the thing. They feel that it justifies being in a pool of one. Um, Whereas if you were permanent and not bound to some specific piece of work or some specific funding stream, I think they would feel that they had to do some kind of proper pooling and, scoring candidates against each other before having a redundancy. I am not sure, however, that the law actually distinguishes this, but it's certainly how the employers treat the contracts. And I think those contracts create some at least aura of legitimacy in doing that, certainly in the minds of many staff. I hope that was clear enough.
Mhm. Yeah, and Vashti is coming back to say, at Edinburgh University, the review date is the end date. There is no review
Okay.
process.
So that's
Um,
just a term. Yeah. Then I think that's, yeah.
yeah. Um, Coming back to the questions, there's Ray's asking a question about a, a term-only contract being issued and asking if that's a form of casualized contract, which I think that would assume on what the contract says, right? Because I know we
What
have
only contract?
a term-only contract.
Like for one term of the academic year?
It says last year I was made aware of a term-only contract being issued. Is this a form of casualized contract? It's certainly precarious.
Yeah, I mean, I guess casualization doesn't really have a legal definition or any or some formal definition. So, for example, our university will tell you that um, these career development teaching fellow posts are not a form of casualization because they're apprenticeships, so they're not apprenticeships. Um, and therefore, it's not casualization because it's opportunity creation. It's not part of relying on casualized labor. The thing is, the way they were negotiated, I think that's true. They were meant to be this sort of career training program that a small number would be used, et cetera, et cetera. But they've not been used that way. They've been used to deliver core teaching services. So therefore, it is a form of casualization because it's no longer about benefiting the next generation of scholars. It's about delivering the university's core service. My view is that anything not permanent or not, long-term sustainable that is primarily to the benefit of the employer and not the employee is a form of casualization. But I don't think there's any official category where we can say yes or no, it is or isn't, I guess.
And before that, I thought I could ask that we have, it depends on if it's term time, you will have some contracts being 4 months term time for a month, and that's obviously a fixed term 4 month contract. You might have, I mean, several universities have had these 9 or 10 month contracts, these kind of term time contracts, and then they end and they have to reapply in September. So I know some
We
universities,
have those.
yeah, so some UCU branches won in making those open-ended permanent, so not term time. So even if the kind of the um you might have annualized contracts, so even if the main work is only for 10 months of the year, you have that kind of ongoing. But if it is a contract that starts and ends, that's obviously a casualized contract.
Mhm. Yeah,
Yeah.
I think these term time only, if we mean only getting paid during term time, I think we do have some that are permanent. And then they're effectively like 0 hours contracts in a way that you don't get paid in the summer. But I'm not really sure of the legal status of that. I mean, in the US, for example, people who are very well paid and very much tenured have these contracts, but it's fine because they get paid enough to live through the summer. Um, so I wouldn't say they are casualized. So I think it probably does depend on exactly what we mean by that. But yeah.
I mean, for a lot of people, I would say also, get in touch with your branch if you haven't already. Get in touch with your branch, and if your branch has a local anti-casualization officer, contact them. If they don't have one, become one. Or obviously get in touch with anyone in your branch or anyone on the anti-casualization committee. Um, uh, uh, Electra has quite an interesting question saying that at UCL, management recently expressed a desire to rename those permanent but subject to funding contracts to fixed term, admitting that it's more realistic. That came from them, not the branch pushing for it. That makes us suspicious, and we decided not to go along with it. Any insight why they would want that?
Um, I don't know what they're thinking. I mean, I think at LSE, for example, they haven't wanted to back away from these contracts at all. But they brought us a proposal to make these contracts, to convert them to permanent contracts. That said, the way they wanted to do it, we won't accept. It's very deprofessionalizing. It's, well, you'll just all be generic researchers who do whatever we tell you to do, and don't worry about academic freedom or anything. And of course, it'll only be if your line manager wants you to be. So we didn't accept the proposal, and they did walk it back a bit, and now it's on the table again. But I think employers are recognizing the problems with these contracts. It creates headaches for them administratively that I think they genuinely don't want. Um, and it's embarrassing for them because we're constantly talking about it and trying to and they know that they sound silly when they talk publicly about a permanent contract that's not permanent. It just doesn't make any sense. I think also there are some maybe not legal risks, and I don't think they're that worried about employment laws so much, but There are these things, like I said, with the internal grants, where they've realized there was a very awkward moment in the negotiation that I can't go into too much detail, but where we kind of said, look, either it's open-ended and therefore it extends beyond the end date of the internal funding scheme, or it's fixed term and it ends before that. You can't say that it's permanent, but that you know it's ending, because then you're admitting that you have an unfair redundancy process. And they kind of just backed away and were like, we need to talk to the lawyers. They literally, I mean, so I don't think that they want to have more fixed term contracts because it embarrasses them to have casualization. But at the same time, they're realizing that they are exposing themselves to looking like they have really unfair redundancy procedures and so on. So I can't speak to the UCL case. I don't have the context, but I think that employers are starting to realize these contradictions could be a reputational, if not a legal risk for them.
Mm. Um, so you have I think there are loads of questions for you, Ian, which I think speaks to the fact that these contracts are everywhere and they're very concerning and also very confusing.
Mm.
Um, so Caleb has a question about what Caleb mentions that they called up the ACAS advice line recently asking about some elements of what's discussed. They said that employers can't just create new grounds for redundancy by putting something like subject to funding in a contract. If they do this, legally, it's only a heads up that a redundancy might happen. But
Mhm.
the reason to make you redundant, for example, loss of funding, has to stand or fall on its own 2 feet, regardless of whether it's in the contract or not. Is this also your impression?
Yeah, so the legal advice we've taken, both sort of in general as part of our negotiations and on specific casework, then where I can't go into too much detail, but the is that of course redundancy is defined in law. Um, Employers don't like that, so we have, like I said, we have the model statute in place and it defines redundancy in accordance with the legislation. And LSE says, no, well, that policy really refers to this type of redundancy and not that type. And that's not the case. So the thing is, I mean, ultimately, the legal definition of redundancy is about an employer needing less of the kind of work being done, not that they need less staff per se, although they're the same thing, right? Um, I think what's really complicated with academia in general and with these contracts in particular is if the kind of work being done is work that is, I mean, it depends on how that gets interpreted. I think if it's work funded by that funder on this topic in that center, then arguably, like the end of that funding would often justify redundancy. So we have tried to say, no, you should look across the entire university and see who's doing roughly similar research, whether that's topic or methods or discipline, and pool if you really, really, really cannot find a way to fund one of, X number of these positions, then create a redundancy pool, score the candidates, and have a fair procedure. Obviously, they don't want to do that. But they would have some argument to say, well, we don't need to do that. Depending again, I think on how the contracts are written. That's what. So yeah, again, the legal advice we have was it does not inherently justify a pool of one, but there might be cases where it does, and it will always depend on the circumstances and the wording in the contracts. I think as just sort of a political narrative for the union, I, and certainly the one that we've probably had the most traction with at branch level has been, well, the onus is on the employer. You need to show us why you don't have to look across the university, why you don't need a redundancy pool, why this is a pool of one, why selecting an individual isn't an academic freedom risk, why it's never going to be discrimination or racism, of any kind. You show us why this is a pool of one and it's a completely fair procedure to not look across everybody doing this kind of work and why there's a legitimate redundancy. So I don't think it's a question we have to answer exactly. I don't think we have to say, well, does this or doesn't this justify it? I think we say to the employer, we don't think it justifies it. You show us that it does. And I think that's probably the way to win this rather than trying to, because we're never going to have a definition that covers all situations, right? There probably are, if you won a fellowship to do something really niche, because often to win a fellowship, you need to be doing something really niche, and it ends, we don't want you to lose your job. At the same time, it probably might be the only type of work of that sort being done at that moment, and maybe it is a legitimate redundancy, and what do you do? That's where employers need better redeployment options and better bridge funding. But yeah, I would just say that the onus needs to be on the employer.
Okay. So I'll just continue with questions. If anyone does want to kind of share their own experience or any strategies from your own branch, do put your hand up. One question is from Christina, and Christina is asking, how common is it for universities to make staff permanent after 4 years on fixed term contracts?
I don't think we know. I think so. UCU is currently doing a national survey and has invited branches to send an FOI request um, to well, the relevant person at the employer to get this data. So I'm correct, right? That is in the yes, that's in the survey. So if your branch has not yet submitted that FOI request, please do so, or get in touch with the relevant staff to make that happen. Um, but I don't think we have the answer.
Mm. And the Lucas is asking, saying thank you very much, very interesting, informative. How do other employers justify it in terms of Regulation 9 in brackets 4, namely that a tribunal would interpret such clauses as they see fit of the document if the document is evasive?
Okay, so I haven't memorized the regulations that
Yeah,
closely.
me neither. So
Um, well, the legal advice we have is that there's no appellate case law on these types of contracts. In fact, there's very little case law at all. Um, and I will just say, I mean, I think that's in part because it it might be hard to take a legal precedent and generalize it to every branch because if they're using slightly different wording or whatever, then and because the damages you're likely to be awarded are very minimal. So there probably just isn't much evidence from the tribunals on how this is handled. So I really don't know.
Um, and then I think not a question, but an example. We have an example from Emily saying they worked for University of Manchester for 21 years and they're on a permanent finite contract renewed in August 2026 until March 2030. And in January was served notice of redundancy just 11 days after the consultation started. Um, that's just
Terrible.
another case. Yeah. And then a question from Andrew saying that we have members who are already at risk of redundancy due to an approaching review end date. Do you have any advice for how they can challenge this as at an individual level?
It would, I mean, it would depend on the policies and the opportunities at that particular branch. To be fair, or not to be fair, that's not the word I'm looking for. Uh, to be clear, I guess once that's happening, I'm not sure that challenging it would be that much different from challenging other redundancies. So, it's about ensuring that there is reasonable redeployment options and so on. I think it will also depend on the funding situation at your university. I mean, I don't have experience of so much winning this in challenging it, but we're starting to look more and more at, well, so LSE has all of these people doing climate-focused research who, are at risk of redundancies here and there. And yet we brought in all this funding for this new global school of sustainability that's just being used to create new casualized positions. So if your university maybe has something like that, maybe you can say, well, look, shouldn't this funding be used for that? And if it's a collective consultation, not individual, I appreciate, then they do have to take that proposal at least into consideration and give you a real response. At the individual level, I think it's holding them to account on things like redeployment policies and trying to find information on availability of funding and really articulating the case for redeployment where it's possible. But no, I don't have great advice because we don't always win these cases.
Um, so I'm looking. So Emily, who had who had been working for 21 years at Manchester, did have questions. Asking if the university have to provide a legal case to make them redundant, stating that it's the end of the funding. Question is, can they end contracts early, even if it is the review date or permanency is in 2030, I think it was.
Um, I mean, an employer can end any contract legally speaking, they could end any contract with a genuine redundancy. So nobody has tenure, right? Nobody's permanent. I think it would be very hard for them to justify if you have funding in place, particularly if you're a named researcher. Like if you win an ERC starting grant and it's locked in with your name on it, nobody else can have it. I cannot see what would justify the redundancy under any circumstances. I mean, I guess the work could be discontinued, but the money's there, so that makes very little sense. Um, Again, I think it's circumstantial. But yeah, sorry, I don't have a specific answer, but I come back to the onus needs to be on the employer in all cases to ensure that there's a valid reason. I mean, you know, as UCU, we say there's never a valid reason. Avoid your redundancies, keep your employees. But at a minimum, they need to be articulating a sound case for that.
And just to mention as well that someone has posted in the questions a link to the regulations 8 and 9 report. So it's kind of laying out steps for how to go about requesting permanency, which is the
Hmm.
first step. And then, you know, these contracts are then the answer to that, right? You say, well, make me permanent, and then you get this contract. But if for anyone here who hasn't gone that step yet, I think that's the first one, right?
UCU has model letters on the website that you can use. I
Yes.
think they're a little outdated because they're not written with these contracts in mind. They're written with fixed term contracts in mind. But if you want to try to treat this as a fixed term contract, I think you could adjust the template accordingly. I mean, I'm
Mm.
not a lawyer, so I shouldn't say that, but I think you could.
Um, okay, so and then we have, I can't see any specific questions. Some Mian is sharing that the HR is also confused. I think a lot of people are confused. People who I know of one member who um, uh, I know one member who just kind of called HR up and said, "What do you mean? What what do you mean I'm permanent? This is not a permanent job. It says fixed term." And then they kind of, they just have to say, "No, you're fixed term, but you're also open ended." And just it makes no sense really.
Oh, I
And
mean,
as you said, it obfuscates kind of rates of casualization, and I'm thinking, I mean, equality issues as well, because if we, as we know, more women, more people of color are on insecure contracts, you're obscuring that fact as an employer.
mhm. Absolutely. I think also I will just say, I mean, at LSE we have, I mean, not that we support this really as a good solution, but there is a policy on minimizing use of fixed term contracts. And then they don't count these for that policy. But they don't even follow that. We see a lot of fixed term contracts, even growing numbers. And we say to the school, what's happening here? And they've told us, well, line managers don't understand which contracts are fixed term and which ones are open-ended subject to funding. So they hire wrongly. And the HR partners don't understand. So they allow them to hire wrongly. And I'm like, well, then clearly these are fixed term contracts if nobody knows the difference and you're not even following your own policies accurately. But
Um, okay, and thank you. I'm just want to mention that the link that was shared by an attendee, it wasn't published, but I think it's visible now. I think it's in the question and answer, so I think that it should be there. So you can have a link to that letter. Um, I don't see any specific questions. I'm guessing a lot of people are asking, well, what do we do next as a union? What do I do next as an individual? I'm assuming many people on this call are on these kind of contracts, or caseworkers, or for people who are on these kind of contracts. So, um, where do we move next in challenging these? That's my question, if I may.
Mhm. So, I mean, well, I had a slide that I hope was at least somewhat helpful. I was trying to say, I think first of all, we just need more information. So genuinely do get in those FI requests. Also, like I said, I mean, if we could get, so LSE, for example, when we requested it, they did give us copies of the templates they use for these different contract types. So maybe we need to start building some kind of archive of this. So what are the differences? Are they all the same across the sector? Because that also informs sort of how useful any legal advice any one branch gets. So I can show you what ours said. Well, maybe I can't show you the exact document, but I can guide you through what it said, but I don't know if it would fully apply at every other branch. It will depend. I think we need to be sharing strategies as we learn lessons of what work. And like I said, we need to remember that permanent contracts are one step on an anti-casualization struggle, that we do need to get people onto them. But if universities continue to spend all their research income on buying buildings and giving massive payments to select favorite, faculty or whatever it is, then there's not going to be funding to keep these contracts permanent, and we will continue to see mass redundancies. So that means, this needs to be part of a bigger picture struggle, I think, that involves lobbying government and so on. Um, and I think also, if you come up with ideas, feed them into the anti-casualization committee, um, or, inform your delegates going to Congress, get them to vote for this motion, that kind of thing. I think it's very incremental and it's going to be very different steps that we need. So I feel like this wasn't a great answer, but yeah.
I thought it was a great answer. I mean, I think sadly there is no easy solution, right? We have to work hard, and I think even just this webinar is one step in the direction. I think in fighting these contracts. I think we should be wrapping up. I'm aware people will have places to go. So I'll do that by thanking you, Ian, and I'm sure you'll have loads of emails in your inbox soon from various members who want to get in touch and work on this. Want to mention again that if you are interested in working more on fighting casualisation, do nominate yourself to stand for the anti-casualisation committee. As I mentioned at the start, you will find that on the anti-casualisation committee's website, but also the fantastic Mary. Meekings will be sending around an email to everyone who registered for this webinar with Ian's slides and also with the link to the template letter to send to your employer for requesting permanency, and also for the call for nominations to stand for anti-casualisation committee. I think that's it. Do you have any final words of wisdom, Ian, or of
No,
energy? Or
no, thank you so much, Lena, and thanks everyone for being on the call. And yeah, do get in touch and do participate. We need, I think that's just the biggest message. We need more information, more sharing of strategies because we just don't have enough now to really say enough concrete things.
so, thank you very much, Ian, and thank you everyone for being here today. And I'm sure I'll see you. Or I hope I'll see you sometime soon.
Thank you so much.